In my last lecture, I discussed the conceptual distinction between justification and excuse. In this lecture, I discuss the first of two excusatory defenses, necessity. Necessity is a common law defense, not found in the code. The leading case on necessity is a decision called Perka. The defendants in Perka were drug smugglers, ostensibly traveling by ship from Colombia to Alaska. They were found in Canadian waters and were charged with importing cannabis into Canada. But the defendants argued that they only landed in Canada because an emergency arose with the ship, raising fears that if the cargo was not offloaded immediately, the ship would capsize and they would drown. They were acquitted. When the case made its way to the Supreme Court, the majority held that a defense of necessity was indeed possible under these circumstances, but found that the jury charge was flawed. The majority articulated a number of principles to guide our thinking about excusatory defenses and a new test for necessity. Chief Justice Dixon, writing for the majority, observed that necessity is a purely excusatory defense. Where it is invoked, the wrongness of one's conduct is implicitly conceded. In claiming necessity, one does not and cannot claim that the law itself is wrong. One claims only that it was not realistically possible for the defendant to obey it under the circumstances. Justice Dixon adopted the analysis of the legal philosopher George Fletcher, finding that the defense of necessity applies only where the defendant's conduct was, quote, morally involuntary. Now, the idea of moral involuntariness is meant to capture the notion that under some circumstances, the defendant could not realistically do otherwise than break the law. This is a loose analogy, only a loose analogy to physical involuntariness. Plainly, we are not talking about a lack of choice in the sense that someone in a, say, state of automatism lacks a choice. And indeed, this is why it is possible to say of the defendant who successfully invokes the defense of necessity that he engaged in wrongdoing. Moreover, recognition that there is a choice in some sense made it important to articulate strict limits on the defense of necessity, lest people treat it as a license to break the law whenever they happen to think there was something more important at stake. As Justice Dixon said, no system of positive law can recognize any principle which would entitle a person to violate the law because, on his view, the law conflicted with some higher social value. We want to recognize human frailties when faced with extraordinary circumstances. We don't want, however, to inadvertently encourage people to think that they are free to disobey the law just because they happen to disagree with it, nor be too quick to conclude that they have no choice. We want breaking the law to be a genuine last resort option. In light of these background propositions and concerns, the majority in Perka articulated what is essentially a three-part test for necessity. First, there must be circumstances of imminent risk where the action was taken to avoid a direct and immediate peril. Second, there must have been no lawful alternative open to the accused. And third, the harm inflicted by the defendant must be less than the harm sought to be avoided. Now, in Perka, it was suggested that each of these criteria would be analyzed on a pure objective standard and determined not by the subjective beliefs of the defendant at the time. This aspect of the test would subsequently be modified in Latimer. Robert Latimer admitted to killing his daughter. She was 12 years old and suffered from a severe form of cerebral palsy. She had the mental age of 4. Her condition was permanent and would worsen over time, but was not terminal. Mr. Latimer killed her in order to end her suffering and avoid the need for more surgery or a feeding tube. He was charged with murder. And at trial, the judge withdrew the defense of necessity from the jury, finding that there was no basis in the evidence for concluding that the test for necessity articulated in Perka was met. Mr. Latimer was convicted. And ultimately, the Supreme Court agreed with the trial judge that there was no air of reality to any of the 3 Perka criteria. Neither Mr. Latimer nor his daughter were in imminent peril. His daughter's pain could be addressed in other lawful ways. So the first 2 elements of Perka were and could not be satisfied on the evidence. And this was the case even though the court somewhat softened the first 2 parts of the Perka test, now allowing for some consideration of the defendant's personal circumstances and attributes. The court also found that there was no air of reality to the 3rd criterion, proportionality between the harm caused and the harm averted. It need not be the case to succeed in this defense, said the court, that the harm caused be, strictly speaking, less than the harm avoided. So even here, the court in Latimer softens the test in Perka. The court in Latimer says it's enough if the harm caused and the harm avoided are comparable. But even so, the court in Latimer found no evidence capable of supporting the conclusion that killing Tracy Latimer was a proportionate response to her suffering. There's one final point I would like to explore today. Are there some offenses that cannot be committed out of necessity? In particular, what about murder? The Supreme Court in Latimer did not categorically rule out the possibility that a person who intentionally kills another might successfully argue necessity. But it is deeply controversial. Let's leave aside here assisted dying for which there is now a limited justificatory defense in the criminal code. We are talking about intentional killings here falling outside the medical assistance in dying regime. In the classic English decision, Dudley and Stevens, Lord Coleridge wrote stridently of the dangers in allowing people to measure one life against another. And the court seemed to all but shut the door on using the defense of necessity in the context of murder. And here we come back to the risks attached to the very existence of the defense of necessity. While adrift at sea, the two defendants killed and ate the cabin boy. They were picked up 4 days later. Had they not killed the boy, they probably would have died of famine. And the boy almost certainly would have died anyway. Now, looked at in isolation, this might seem as clear a case as any for allowing defendants to use the defense of necessity. If they had a choice, it doesn't seem like much of one. And to our eyes, it seems like such a bizarre set of circumstances. Why not recognize the defense in a case such as this? Suppose I told you, though, that this wasn't an isolated one-off case. What if I told you that there had been a growing practice amongst 19th century sailors to resort to cannibalism in the event of shipwreck? Perhaps that would make you think differently about Dudley and Stevens and the choice that the judges had to make. Because if they recognize the defense of necessity in their case, they aren't just sending a message to Dudley and Stevens. They are sending a message to all those sailors out there, in effect, that it is okay to keep killing and eating one another. Your concession to human frailty becomes a license to commit murder. And that is really the riddle of the defense of necessity. How to acquit those who truly had no realistic choice, whose conduct was morally involuntary, while ensuring that the validity and authority of the law is not itself called into question. This brings me to the end of my brief first lecture on excusatory defenses. In the next lecture, we turn to the twisted story of the evolution of duress. See you then.